it's kind of a 1-2 punch. The EB5 investors are really dealing with uncertainty on both ends.
Right. And the investments are significant. So, of course, that makes the stakes a lot higher in those cases as well.
Welcome to Statutes of Liberty, an immigration podcast brought to you by Klasko Immigration Law Partners. The United States is many things: a great melting pot, a nation of immigrants, a land of opportunity. Millions have journeyed here seeking freedom and the chance for a better life. Belief in the American ideal means providing opportunities for everyone, regardless of race or birthplace, to achieve their highest potential. Join us as we unravel the ins and outs of immigration policy, from the issues of today to the historic basis for laws already in place.
Welcome back to the Statutes of Liberty. I'm Natalia Gouz, a Senior Associate at Klasko Immigration Law Partners. Today, I'm joined by Jessica DeNisi, a partner at the firm. Jessica was instrumental in the firm's response to USCIS's adjustment of status policy change in late May, which we are discussing today. Jessica also has background with the U.S. State Department and brings a really unique perspective, especially as we get into the consular processing piece of our conversation. Today, we're talking about USCIS's recent policy memo on adjustment of status, and we'll dive into what it says, what we've been seeing play out in practice since it came out over a month ago, and what it might mean if you're weighing your options on how to get your green card, as well as some tips for employers sponsoring workers for a green card. So, welcome, Jessica. Thank you for joining us.
Thank you.
To start, I'd like to ask you, when this memo came out, can you walk us through what were the first things that you looked at and what were your initial reactions?
Well, I think there were a number of important parts about of the memo when it came out, but I think the fact that USCIS does not view this as a new policy per se was important. In other words, from the way we were looking at it, it applied to everyone. It would impact all cases. So I think we really started then looking at what considerations there were, what things that we need to do, what actions we needed to take for people that were at different phases of the process. So, we had to make decisions and think through how were we going to advise new clients that we were just meeting for the first time about considering AOS and, what to weigh. Those people who were existing clients who were in the process of filing your AOS, and we were already working with them, maybe we needed to start looking at different factors, whether they were eligible for consular processing, what the rest of their immigration history was. There were things that would be weighed differently, now that the memo had come out, and then, also those people who already had pending adjustment status applications. Did we need to interfile? Did we need to withdraw? We just started thinking through how we would help an entire range of clients at different stages in the process.
And I know that our inboxes were flooded immediately after the news of the memo came out, and there was a lot of panicked emails from individuals who had pending adjustments of status. And so was it clear right away that this was going to apply retroactively to adjustment of status cases that had been pending, or whether this was going to apply to new cases filed after the memo went into effect? Was that something that you looked at that early stage, or was it pretty clear?
Well, I don't know if anything was crystal clear when the memo first came out, on a Friday afternoon. So, I mean, that is one of the things that we talked about. But USCIS did seem to be taking the position that this was nothing new. This was just, I guess, additional guidance on how to apply discretion in these adjudications. And they were certainly taking the position that, this had always been the situation, citing various cases, and things of that nature.
Right. And then when I first heard of the news, I was pretty shocked. And then I read through the memo, and I understood that they were relying on their discretionary power to deny an adjustment of status case. And so, what were some of the things that you thought about with the team that we could do, particularly for those individuals who had a pending adjustment, right? Because for people who are still going to file their adjustment of status, we kind of had the advantage of taking a pause and seeing if we needed to adjust the strategy, submit some additional documentation. But for somebody whose priority date is current and their adjustment of status has been pending for several months, what's the immediate action? What did you think we could do right away or give them an option to do?
We immediately started talking about, potentially interfiling adjustment of status applications that were already pending, with evidence of, the positive equities, did they live here? Did they work here? Did they have family? What sort of non-immigrant status they had been in when they filed, and then also sort of, right on the heels of the initial memo, we had the additional announcement from USCIS that suggested that persons who were providing an economic benefit, or somehow the adjustment was in the national interest, that would be looked on favorably. Did we need to interfile evidence of that as well?
Right, and then we had some webinars, we had client alerts, we had webinars for employers, we had webinars for employees and individual clients, because there was just so much to unpack and really drill down on what were some practical things that we could suggest to our clients at that point. Our firm, we have several practice areas, right? We have corporate practice areas where we primarily interact with HR partners, legal partners regarding the sponsorship of the employees. We also have individual client units where we more directly interact with individuals who retain our services. You also lead our investor visa program, including EB-5. And so when you were looking at this, in the first few days and, coordinating our response, were there factors and sort of things that you thought about with the team as to how to address this with those different sets of clients, whether it's corporate clients, whether it's EB-5, whether it's individual clients?
Yeah, we did talk about that. I do primarily work in the EB-5 immigration space, and many of our individual EB-5 clients, who are seeking a green card through that investment process, they're here on H-1B visas. They're just the timeline, the backlog, the wait period for an EB-2 or an EB-3 green card for a lot of those people was just too long to be practical anymore. So then they shifted to an EB-5 investment. So, for these people, the ability to adjust status and remain in the US was very important here, right? They've been living here for years and working. They have houses, families, jobs, obligations, and traveling for consular processing. It would be a significant disruption. I think that for EB-5 in particular, the mention in the memo of H-1Bs and L-1s, I think that was certainly notable, right? The memo states that H-1B or, H-1Bs and L-1s are dual intent visas, but also sort of suggests that in and of itself is not going to be sufficient. For EB-5 clients, I think that was one of the things that really kind of gave everyone pause.
Hmm. Yeah, I'm always interested to hear more about EB-5 because I've focused my practice on corporate practice where we do the H-1Bs, L-1s, and other employment-sponsored visas and green cards. But EB-5 is a whole different world when it comes to immigration sponsorship. Is there anything else in particular that applies to individuals who file an adjustment as an EB-5 investor, maybe issues that come up regarding the actual investment, the source of funds that even though that should be adjudicated at the petition stage, have you seen issues relating to that come up somehow, maybe directly or indirectly at the adjustment stage?
I think that the issues that we see with EB-5 investors in particular is just, you know, while all of this is going on, while, when the memo came out and we're kind of dealing with this shift, EB-5 adjudications are somewhat volatile, right? So we were seeing a lot of new trends in the adjudication of that initial petition, the 526, the 526E petition, and new denials or revocations on issues that weren't previously issues that would lead to a denial. So I mean, it's sort of a lethal combination when you see a lot of volatility and change and unpredictability in that initial petition adjudication, then, in tandem with the, one would say heightened chance of, denial at the adjustment of status stage, it's kind of a 1-2 punch. The EB-5 investors are really dealing with uncertainty on both ends.
Right, and the investments are significant, so of course that makes the stakes a lot higher, in those
Yeah.
cases as well.
And we're seeing, for EB-5, there's a grandfathering deadline coming, September 30th of 2026. So investors who filed before this September 30th deadline this year, they're protected from being denied, essentially just because of the expiration of the legislation. So, people need to move quickly now, and the consequences of something negative happening down the road, I think, are a little bit more severe, because in addition to the general immigration benefit, they would lose the ability to be protected by this grandfathering clause if for some reason something happens, and they would need to refile or can't proceed under the initial petition. I know, have sort of on the front line of the interview experience. So what have you seen at the AOS interviews and adjudications since the memo came out?
Yeah, I would say that the implications were pretty immediate, right? Like, we were seeing and hearing about this, like, within probably the next day when the memo came out. So we were getting reports that people were going to their adjustment of status interviews and officers were asking them additional questions. They were asking, why did you choose to apply for adjustment of status instead of going back home to your country and consular processing this final step of the green card process at a US consulate? Why would it be difficult for you to do so? And I think that, is a surprising question, right? Especially for individuals that were not prepared for that question because it has been practiced for decades that, individuals who are eligible to file the adjustment of status in the United States, that is naturally what they would do, so that they could remain here, they can continue working, pursuant to their non-immigrant visa. They can remain here with their family instead of having to depart at short notice and go to the consulate and not really know how much time they would have to spend abroad to complete that process. So filing an adjustment of status, there was never really a need to explain, well, why are you choosing adjustment of status versus consular processing? So we started seeing individuals get those questions at adjustment of status interviews. So then immediately we thought, okay, well, if we have clients going, we need to prepare them to answer those questions. And that was also part of our consideration with the interfiles of, addressing those questions and also thinking about future adjustment of status applications, that may be something that needs to be addressed up front, even though what's interesting is that those questions are not on the form I-485. So I think clients were surprised. And it really did vary across different field offices, right? Because adjustments of status are adjudicated across different field offices across the country. And we always see a variation in their approach and how they handle things. But we definitely, we were collecting information. This happened in Miami, this happened in California, and we were just gathering all of those details. We also saw that some adjustment of status interviews were canceled, that were scheduled like within the next week or two, then to be rescheduled, probably because the field offices really did not have concrete guidance about how this was to be implemented. And this was, to give them some time to figure that out. We also saw that requests for evidence were issued or even handed to the individuals at the interview to answer these questions. But also, we have reports and we've had cases approved, as recent as last week, where there were no interviews, there were no RFEs, and these questions were not asked. And so, we've seen the impact, but I don't think that it's been consistent. And it does seem like some offices are asking more, others are not asking. So I think it's still to be seen how this will actually get implemented because it doesn't seem to be consistent, at least at this point.
Like so many things. So when you're talking to clients about what to expect, what are they concerned about? What are the big stress points that you're hearing?
Well, I think news spread pretty quickly that individuals were, concerned about how to address these questions. And, I think in some cases, for example, if somebody, came here on a non-immigrant visa and married a U.S. citizen, I think the answer's pretty clear. Well, my life is here. I married a U.S. citizen. Of course, I want to stay with my spouse, with my family, and complete the process in the U.S. rather than disrupting our life and going abroad. But for some others who maybe came here on a student visa and then switched to an H-1B, or were here on another non-dual intent visa, I think that's a little bit more nuanced, right? To kind of explain that, well, you may be questioned about the fact that you came in on a single intent visa and then you filed for a green card. So, kind of understanding what the officer may be asking and understanding how to explain things. I think, I also received questions from individuals about, well, what are some additional documents that I should be bringing to the adjustment interview to help show that, that I'm a good person and that I deserve this discretionary benefit. I mean, I'll be honest, I think a lot of clients have been concerned about just having to go to USCIS for an adjustment of status interview before this policy memo came out, just because of everything that has been going on and all the strict scrutiny and detentions. But this in particular, I think, really made clients worried about what to expect. But I think we were thanks to you and the team and everything that you did in those first few days to help us develop the materials, and the guidance. I think when our clients came with those questions, we were able to give them really concrete and practical guidance, relatively quickly as to how to address this situation. Another aspect that I wanted to cover in this discussion, and this has to do with consular processing. And Jessica, you have experience with the Department of State, so you're definitely the perfect guest to talk to about this on the podcast. But I wanted to give a little bit of background why it's relevant now, right? Because again, and I think because it really has been the norm that individuals are filing adjustment of status applications from within the US. People are generally familiar with the I-485 adjustment of status process. You file the application, you have to submit a medical, you may need to go for an interview. And then, hopefully you get your green card. You don't have to travel. You can stay here. But of course, there is an alternative process where individuals can complete the final step of the green card process at the consulate abroad, where the consulate reviews all the documentation and determines whether the individual is eligible to obtain permanent residence, and then they can travel to the United States with that immigrant visa and then get their green card when they're here. But now, if adjustment of status is going to be viewed so strictly, and if USCIS is really going to only grant it in those extraordinary circumstances, I think it's really important for our clients to understand what is consular processing. How does it differ from adjustment of status? And I think it's particularly important to understand that because you have to make that decision earlier in the process, right? So when an employer files an I-140 petition, or when somebody sponsors their family member on an I-130, or even in the EB-5 immigrant petition, you have to indicate, will this person adjust status in the United States, or will they consular process abroad? And in some cases, the immigrant petition is filed several years before that adjustment of status or consular processing is filed. And they need to indicate that at the immigrant petition stage. And now we know that if you check consular processing, you can then switch to adjustment of status relatively quickly by simply filing with USCIS if the circumstances change. But the opposite is a lot harder. If you indicate that you will adjust status and then you need to consular process, you need to initiate that process with the National Visa Center by filing another petition with USCIS, which can take an additional year, if not longer, to get that mechanism of notification going. So, for that reason, I think it's really important to understand how those two processes work. So, I would love to hear from you about how consular processing works. After the petition is approved, what are the steps that the case would go through?
It's interesting for EB-5 investors, they were only given the opportunity, the option of adjusting status in 2022 with the passage of the EB-5 Reform and Integrity Act. So before that, for EB-5 investors, it was all consular processing. I think given this memo, consular processing now, it has the advantage of sort of not making someone subject to this discretionary framework, but it sort of comes with its own considerations, like you were saying. Obviously, if you are having to leave the U.S. in consular process, then you are potentially subject to any issuance or travel bans or whatever that may be in effect at any given time. Which is obviously something that would not impact you if you were in the U.S. But beyond that, like you mentioned, you have to first deal with NVC and the process of getting documentarily complete. And then after that, once that process is done, and as you said, that process can take quite some time, then you have to be scheduled for an interview and wait for the opportunity to interview. And depending on, where you have to interview, that wait time can vary dramatically. We're seeing, people processing in, Abu Dhabi who have been waiting for, years for an EB-5 visa interview, in particular. We also see for EB-5 investors, I'm sure this is true of other people interviewing for different categories. A lot of scrutiny depending on the country in question. We've seen a lot of our Chinese investors face additional questions about having to do with national security. Who employs them? Obviously, if there's some connection to the Communist Party, something like that. We've seen investors in, India, Vietnam, some other places who, at the consular interview, the consular officer will kind of reopen a discussion on their source and path of funds. So they're getting that re-adjudication there again. And sometimes, being stopped in the process after originally getting approved, with USCIS, with the 526 or the 526E petition. And then obviously for anyone, once you depart the US and you go for consular processing, you lose any of the benefits that you would have had from remaining in the US. You start having to look at, unlawful presence or, bars to reentry, things like that. It's just a different set of circumstances. You're weighing different factors, right? So assuming that both options are available to you, people are going to want to look at, country of origin, immigration history, and basically just weighing, looking at your risk tolerance, under both options.
Yeah, exactly. I think now we really have to look at all of these factors a lot more closely in deciding whether, helping the client decide whether they will adjust status or consular process. Because if consular processing is an option, then, or is the better option in their case, they need to understand that, they're going to have to coordinate police clearances, medical exams in their home country. Usually, appointments at consulates are scheduled about a month out, right? So they don't really, foreign nationals won't really have that much notice, right? So you're kind of sitting, waiting for that interview to be scheduled. You get the notice. Usually, you have about a month. You have to coordinate travel quickly, potentially with your whole family. You have to stop working, potentially take kids out of school, go to your home country, get the medicals, get any additional civil documents that you need, attend the interview, and then potentially wait a week if you're lucky, right, to get that immigrant visa and then come back here. It could be pretty disruptive and something that employers and individual clients would need to plan for. Some new considerations with this policy. Well, thank you, Jessica, so much for your insights and this discussion. So, I think our takeaways here are that this policy definitely shows a shift in how adjustment of status applications will be adjudicated. We've already seen practical implications, but of course, it's only been a month. So we will continue to monitor the process, and have those conversations with our clients about consular processing, adjustment of status, and maybe, that the strategy will need to be changed or refined in some cases. So, as always, we'll continue to monitor developments in the immigration space. If anybody has any questions about your case or would like to discuss this more at length, we invite you to sign up to our client alerts, subscribe to this podcast, attend our webinars, and of course, schedule a consultation. And thank you so much for joining us. We hope you have a great rest of your day. And thanks again, Jessica.
Thank you for listening to Statutes of Liberty, an immigration podcast brought to you by Klasko Immigration Law Partners. For more information, visit us at klaskolaw.com. Follow us on LinkedIn, Instagram, and Facebook. You can email your immigration questions to podcast@klaskolaw.com. The materials contained in this podcast does not constitute direct legal advice and is for informational purposes only. An attorney-client relationship is not created by listening to or accessing this podcast. The information provided should never replace informed counsel regarding specific immigration matters.